My release, my lord. My lord, the matter pertaining to the transfer has already filed this morning. So this may be taken up at the, my lord, unlisted matter. My lord, the same matter is already listed in item number 8 in today's list. Similar matter.
Item 8.
My lord. So this may be taken
Okay.
up.
Mm.
Oh, bless.
Is it-
Lordship,
May I please?
Yes.
I beg to mention item number 12. Your Honor.
Yes.
Your Lordship, my senior, he is out of station. Therefore, this matter may be adjourned. Lordship. I have informed Lalit PP also.
You are Mr.
B. Mandal.
You are for the petitioner.
Yes, Lordship.
Who is for the respondent?
I'm for the private respondent. I was not informed. However, there is a interim order, Your Honor.
Yes.
This is a POXO case. And the investigation has been stayed because
This
of the.
criminal petition is POXO case.
Yes.
Yes.
So the petitioner is protected by the interim order.
Yes.
12. Yes.
Item 12 you're talking.
Yes.
Yes.
Item 12. However, I have no objection if senior is absent, Your Honor.
Okay. You are Mr.
B. Mandal.
Lana Council submits that his senior is out of stations and prays for adjournment of the matter for
2 weeks, Lord.
2 weeks, to which the Mr.
R. Raksa.
Lana Council for the respondent has no objection. Stop prayer allowed. List this matter after 2 weeks.
Deeply honored.
Oblige, Your Honor.
Lordship, I would like to mention item number 15. Your Lordship, I need 3 weeks time to file my affidavit, Your Lordship. Item number 15.
15.
Yes, Lordship.
You have to file affidavit.
Affidavit, Your Lordship. 3 weeks may be granted, Your Lordship.
Petitioner is present.
Lordship.
Okay.
Lordship,
You are
interim
Mr.
order is there, Lordship. Interim order is there. Maybe continue, Lordship.
Okay, just a minute. In the earlier case, there was in interim said, who said? Item 12. Let us see the item 12. There is interim order.
Yes. In
Rank
favor of
ranks.
petitioner.
Hmm?
Yes, there is a stay order.
Okay. In item 12 also, the interim order passed earlier shall continue till the next date. Okay. Otherwise, now it is 15. Mr.
K. Tawang, Lordship.
Land Council for the petitioner is present. Miss
Arbasar.
Arbison. Land Council appearing on behalf of the state respondent. State respondent.
Yes, Your Lordship.
Prays for how much time?
3 weeks, Lord.
For the 3 weeks time to file affidavit in opposition. The prayer is allowed. Release this matter after 3 weeks. Okay.
Lordship, item number 24 also, Your Lordship. Here also we have
In the
to.
15, you say that there is
Yes.
interim. In
Interim.
the 15 also. Para, the interim order passed earlier should continue till the next date. Huh? Okay.
And in item 24 also, we have to file affidavit, Your Lordship. 3 weeks, Your Lordship, may be granted.
24, who is for the petitioner?
I'm appealing for the petitioner. Your Honor.
Okay,
There's an interim order, it may be continuing.
okay. Miss Same, huh? Prays for further, appearing on behalf of the state respondent, prays for further 3 weeks times to file affidavit in opposition. Mr. You are Mr.
Idagbam.
Land Council for the petitioner is present. Stop. List is as prayed for, comma. List is matter after 3 weeks. Stop. Para. The interim order passed earlier shall continue till the next date. Okay.
Obliged.
My lord, I beg to mention item number 9, ma'am.
Item 9.
Yes, my lord. Matter may be adjourned for today, madam.
Okay.
I am the
Scenario
respondent.
is not, you are for the petition.
I am for the respondent, ma'am.
Respondent,
Yes,
have you informed the petitioner?
yes, yes.
Mr.
The
The other learned counsel for the respondent with the consent of the learned counsel for the petitioner prays for listing this matter after
3 weeks, ma'am.
3 weeks. The prayer is allowed. List this matter after 3 weeks. Okay.
Much obliged.
My lord, may I mention item number 16? I'm for the petitioner here.
You are
I-
for the petitioner.
Yes, I have taken the consent. I have taken the consent from the other side.
Okay. When do you
We-
want?
This matter may be taken after 2 weeks. 2 weeks time again.
You are Mr.
M. Khambo.
Mr. M. Kambo, learned counsel for the petitioner with the consent of the other side prays for listing this matter after 2 weeks. The prayer is allowed. List this matter after 2 weeks. Okay.
Obliged.
May I please, my lord?
Yes.
My lord, I beg to mention item number 27, ma'am.
27.
Yes, ma'am. I have taken consent from the other side.
Criminal appeal.
Yes, I am for the appellate, ma'am.
Okay. Mr.
M. Doji, ma'am.
M.
M. Doji, ma'am. M. Doji, ma'am.
Okay, learned counsel for the appellant with the consent of the other side prays for listing this matter after
After 3 weeks, my lord.
3 weeks. The prayer is allowed. List this matter after 3 weeks.
Obliged.
May I please, Your Lordship? Your Lordship, I pray for an adjournment of item number 11 on behalf of Mr. R. Saikia, the standing counsel for the NIT. This matter may be listed after 2 weeks.
Who is for the petitioner?
Okay.
Okay. Mr.
Idak Bang.
Okay, learned counsel appearing on behalf of Mr. Rintu Sankhya, SC, NIT, prays for adjournment of the matter for how much time is
2
it?
weeks.
2 weeks, to which the learned counsel for the petitioner has no objection. Prayer allowed. List this matter after 2 weeks.
My lordship, I'd like to mention item 18 on behalf of Mr. D. Kamduk, Standing Council Land Management. 18. Your Honor, this matter may be listed after 4 weeks. The standing
Have you
council,
informed the learned counsel for the petitioner? Petitioner is present. Okay. You are Mr. Petitioner, Mr. Learned counsel for the petitioner is present, sir. Mr.
J. Koyur.
Appearing on behalf of Mr.
D. Kamduk.
Dugma, D.
Yes, Your Honor.
Kamduk, learned counsel, sorry, learned D. SGI.
Your Honor, Standing Council Land Management.
That's standing counsel
Land Management.
for land management.
Yes, Your
Okay, sorry. Praise for adjournment of the matter for
4 weeks. Yeah.
4 weeks.
Yes, Your Honor. Meanwhile, we'll filing our
objection.
counter affidavit.
Okay. The prayer not objected, so accordingly, the prayer is allowed. List this matter after 4 weeks.
Lordship, there is interim,
Staff, para. The interim order passed earlier shall continue till the next date. Okay.
Obliged.
My Lordship,
Yes,
I'd like to mention item number 26.
26.
And I on behalf of T. Tapak for the petitioner.
Okay. Have you informed the other side?
Yes, it's important.
Mr., you are Mr.
K. N. Tatik.
Appearing on behalf of Mr. T. Tataklan, counsel for the appellant with the consent of the other side. Praise for listing this. When do you want, you said? When do you want?
After 2 weeks.
Matter after 2 weeks. The prayer is allowed. List this matter after 2 weeks. Okay,
Lordship, you may.
yes,
Lordship, I beg to mention item number 20.
20.
Lordship, this matter is fixed today for appearance of the respondent number 2. Lordship, they have entered they have present today.
6 4 4.
For service upon respondent number 2, Lordship. I've been informed they have filed their wakalat nama today, Lordship.
So the respondent number 2 is appearing.
Yes, yes.
So we are
Okay.
praying that, Lordship, this matter may be fixed for admission on the 6th of November, Lordship. This is a long pending matter, Lordship.
Mr.
Gitalo, Lordship.
Land Council for the petitioner. You are Mr.
Tigao, Your
would appear on behalf of the respondent number 2 and praise for something. Okay. Would appear on behalf of the respondent number 2, huh? Stop. Well, is prayed for. Least this matter. So what about the other respondent?
It is the state, Lordship. It
Hmm?
is represented by the learned prosecution, Lordship. Respondent number 1, the state of
Okay,
AP.
this is okay.
So we are praying for fixing it for admission hearing, Lordship.
Oh, then appearing on behalf would appear on the respondent number 2, who pray for some time to go through the petition. Stop. Prayer allowed. Least this matter. After 2 weeks for admission. Okay.
Lordship, can it be after 1 week, Lordship? It is a pending
After
matter.
1 week,
If a fixed date could be given on 6th of November, Lordship.
6 November.
Yes, Lordship, because this is totally based on the record, Lordship. So
Okay. Please pray for, least this matter on 6 for admission. Okay.
Lordship, there is an interim order that may be kindly continued.
In the meantime, the interim order shall continue till then. Huh? Okay.
Much obliged, Lordship.
May Lordship,
Yes.
Lordship, I beg to mention item number 17.
17.
Yes, Lordship.
Yes.
Lordship, the conducting council is out of station on medical ground. And I have taken the consent from other party.
You are for the petitioner.
Yes, Lordship.
Okay. Mr.
Tigao.
Submits that his senior is out of station and prays for adjournment of the matter for how much?
4 weeks, Lordship.
4 weeks.
Yes, Lordship.
4 weeks. Prayer not objected. List this matter after 4 weeks. Okay.
Lordship, may. Lordship, I beg to mention item number 10, Lordship.
10.
Yes, Lordship. I informed the other side. Can this matter be listed after 1 week, Lordship?
You are for the
Petitioner,
petitioner.
Lordship.
Mr.
Gitalo, Lordship. Gitalo, Lordship.
G. Tallo, Land Council for the petitioner with the consent of the other side. Prays for listing this matter after
1 week, Lordship.
a week. Prayer allowed. List this matter after a week. Okay.
Much obliged, Lordship.
Obliged.
May I please, Your Honor? But I
Yes.
beg to mention item number 28. This matter may kindly be fixed after 2 weeks, Your Honor. I've taken consent from the other parties.
When do you want to say?
After 2 weeks.
Miss
T.Y. Bhutia.
Land Council for the applicant with the consent of the other side. Prays for listing this matter after 2 weeks. The prayer will list this matter after 2 weeks. Okay.
Deeply obliged.
My lord,
Yes.
I beg to mention item number 23.
2, 3.
Yes, service report is still awaited here.
Service report awaited.
Yes, still is
In
awaited.
respect of,
Petitioner,
in respect of which respondent?
respondent number, I think it's 2.
Wait for some time. Wait for some time. I wrote BG.
Okay.
Okay.
Obliged.
May it please your lordship, my lord. I think I am audible.
Yes, yes. Sir.
Yes, my lord, this is a contempt. And my lord, I am just praying for a notice to be issued in this case. If your lordship like to look into the judgment at page 24, kindly see judgment of page 24. This is a land acquisition matter. Kindly look 24, just before para 11. Just
Yes.
for para 11, the learned district judge come at page 24, just before 11, para 11.
Yes.
The learned district judge come presiding officer land acquisition rehabilitation so and so has passed the judgment order dated 7/5/2021 by which the said objection disposed of by directing the Union of India through a response number 4 to make the payment of compensation amount of 83 lakhs so and so to the petitioner within a period of 2 months with the interest at the rate of 6% from date to award till realization. Now, my lord, today we are in 24. Thereafter, they challenged before this High Court. Once they challenged, they lost. They came to the High Court. High Court remanded the matter. Again, it went against them. Now, when it went again, they challenged the acquisition notice, land acquisition notice, which your lordship will kindly see, which went against them at page 32, page 20, page 30, because during the course of hearing, what we said, if you are not interested, please return the land to us, which was not a part of the pair. And how the court dealt, my lord, kindly see that at page 30, para 25. Kindly see para 25.
Yes.
Be that as it may, although it is not a prayer made in the writ petition for return of the land, but having heard the learned DSGI and with the consent given by the learned senior counsel for the respond number 4, it is provided that in the event the appropriate authorities of the Union of India takes a decision that the entire land of the petitioner is not required, such a decision would be taken within 7 days time from today, that is within 23/9/2024, and the same to be communicated to the respond number 4 and disclose the readiness and willingness to hand over the entire land to the petitioner within next 7 working days, that is within 30/9/2024. It would be open to the Union of India to make such an offer to the respond number 4, and it would be open to respond number 4 to take appropriate decision and communicate to the concerned authority within 2 working days from the date of receipt of such communication. Respond number 4 shall communicate his email address to the petition number 4 so as to facilitate faster communication between them. Kindly see 26. As the above part of the order is not prayed for, this court is inclined to provide that in the event the timeline mentioned above is not adhered to, the said offer would stand lapsed irretrievably from the petitioners, and no prayer for extension of time would be entertained in future. It is also made clear that there would be no extension of time because the petitioner have not been able to show under the Act of 2013. It is open for the state or for the acquiring authority to alter the position except under the circumstances provided under Section 101 of the Act of 2013. It is also interesting to note on the prayer made by petition number 1, repentation by respond number 4 in LA appeal number so and so, the order dated so and so was passed by learned district judge in connection with reference case. Said order is not assailed by the petitioner. Petitioner is, my lord, the government of India. And therefore the said order dated has attained finality, that which order I have shown. Accordingly, without any challenge to the order passed in reference court, the challenge made writ petition against the land acquisition notification, which was published in Arunachal Pradesh Gazette as well as award dated 1/6/2020, cannot be held to be maintainable. For the reason the court do not find any merit in writ petition, and the same is dismissed, subject, however, to the observation in para 26. So the Union of India lost the case. After the judgment was passed, we communicated at page 33. Kindly see, my lord, we communicate the matter after the judgment was kindly see the subject. Forwarding of the judgment and order in Union of India so and so. Number 2, directing judgment to decide whether the land in question is required. Number 3, Honorable Court directs judgment to confirm the willingness and readiness. Now, they said they are not, they will take the land. Now, kindly see, my lord, there is an order, there is a letter which has been written by them at page 40. Kindly see 40. Kindly see 40. 23/9/2024 letter at page 40. First paragraph. In reference to case number so and so, title Union of India versus so and so, the Honorable Guwahati High Court, Itanagar Permanent Bench and judgment dated, it is hereby informed ITBP will retain only 2081.25 square meter and staging camp for which MLA has issued sanction, wide sanction order dated 2/11/2021. Already it has been sanctioned. There is a judgment passed. Now at page 45, Kindly be seen, my lord, at page 45. See para 5. This is Union of India has written to the Deputy Commissioner. ITBP has written to the Deputy Commissioner on 28/9/2024, my lord. Kindly see para 5. In the light of these circumstances, see paragraph 5. To comply with court's order, I respectfully urge your esteemed office to promptly calculate, assess, and intimate this office total compensation amount as per existing land rules to be paid to landowner, area measuring only so the High Court's order may apprise and further process may be finalized. There is no question of finalizing or assessing the amount. Amount award has been passed already. Now, realizing the mistake made by them at page 46, they withdraw this letter. Kindly say they realize the mistake when they have written letter. Kindly see, my lord, at 46, 29/9/2024 letter. On the next day, it is to inform, since the information subjected above has already been provided by your good office while letter dated so and so, hence this office letter dated 28/9 regarding the subject cited above may be treated as withdrawn, cancelled. Even today, my lord, from since 2021, they have not paid a single amount. Even they lost all the battles in the court. So only my prayer today is that your lordship will issue a notice. Notice, because the contempt, kindly issue a notice. Notice to at cost title at page 2, my lord. And the government of UMS, the state is saying that please comply the order of the court.
Okay.
Yes.
Heard, Mr.
Mr.
Heard, Mr.
D. Das, senior counsel, my lord.
National Council for the petitioner. Stop. Para. This is an application under section 11 and 12 of the Contempt of Courts Act 1972, read with 215 of the Constitution of India for violation of the order dated 16/9/2014.
16/9/2024, my lord.
Sorry, 2020.
2024, 16/9/2024.
It's not 14.
No. My lord will kindly see the
Correct
judgment.
it.
6/9/2020.
2014.
2024.
Passed by this court in WPC number 374 of 2022. Stop. Tara, issue notice. You're assisted by him.
Lordship.
You're assisting.
Yes,
him.
Lordship.
Okay, assisted by him. Huh? His name, good, your good name?
K. Mena, Lordship.
Okay. Issue notice. Returnable by
My
4
lord,
weeks.
only one prayer, my lord, before your lordship
Yes.
is to disturb your lordship. My lord, can it be on returnable on 19? Because I'll be there in Arunachal Pradesh, one of the matter. And in the meantime, we'll take a justice service on 2, 3, 4 days from Itanagar itself. If you see at cost title 2, page 2, cost title. At page 2, we'll take a
19 of
this month.
November.
Yes, 19 of November. And in the meantime, it will be more than 2 weeks. It will be more than 2 weeks. It will be more than 2 weeks.
Itanagar, Lohit.
These are the 2, 3, 4 is, we'll take a justice service, the addition to the notice to be issued by this court.
Returnable by 3 weeks. Huh? The petitioner shall take steps upon the respondents by registered post with AD as well as usual process. Stop. As prayed, comma. The dusty is also allowed. Stop. Huh? Para. As prayed for, comma. List is matter on On which date you said?
19th of November, my lord, 19th of November.
19/11/2024. Okay.
I am deeply obliged, my lord, deeply obliged.
Sorry.
Yes.
If I may please, Your Honor.
Mm.
Your Honor, this application has been filed challenging the NBWA orders passed by the learned Special Judge NDPS Bomdila because the accused person, Shri Kamal,
NBWA issued by
by the learned Special Judge NDPS Bomdila.
Bomdila.
Yes, Your Honor.
Okay.
And the impugned orders, Your Honor, is at page number 124, 125, 127, and 143. Initially, Your Honor, the accused person was granted bail by this honorable court, and the order of this honorable court is at page number 105.
Yes, sir. Where is the impugned order?
Impugned order is at
124.
124. Order dated 12/12/2023. If I may read, Your Honor.
Yes.
If I may read, Your Honor.
On 3 occasions, he remains absent during trial.
What is his name?
Page 123, 124, and 125.
What is the name of the?
Kamaluddin.
Third line, Your Honor, in page number 124.
Is 23 also?
123, yes. From
Kamaluddin.
yes.
Kamaluddin.
No. 123 NBWA was issued to some other, not to Kamaluddin. Okay. By 12/12/23, Kamaluddin was issued.
NBWA was issued to him. Thereafter,
NBWA.
yes, Your Honor.
Okay. And which one? Next
Thereafter,
is
on 23rd February 2024, fresh NBWA was issued again. The last line at page number 125. And then on 8th April 2024, Your Honor, the accused person had personally appeared before the honorable judge, and he had also filed for recalling the NBWAs, but the same was rejected, and that rejection order is
8/4/2024.
8/4/2024. This
What did you
order-
say?
He appeared before the honorable judge
On 8th.
on 8th,
Okay.
and he had also filed for recall application for the
Okay.
NBWA, but the same was rejected.
He appeared before the
He
court.
appeared.
Was he taken into custody thereafter?
After rejection, he was taken into custody.
Taken into custody?
Yes, Your Honor.
Okay, then?
My submission is that, Your Honor, the accused person was granted bail by this honorable court on 31st October 2022. Thereafter, he was appearing for
Bail
trial
granted in what, which case?
in this particular case.
In the case?
In the same case, he was
Not
granted-
against the warrant issued against the accused.
In
That is different. That is different.
In that case itself, Your Honor, he was granted bail. However, the honorable judge had
That was in the initial period.
initial period,
Yes, that is not connected now.
and then he was attending the trial. The conditions of the bail was such that he would attend the trials, and then he was attending.
But he did not attend. That is why the learned court issued NBWA.
Yes, Your Honor. The thing is that the learned judge should have at least issued a summon or a bailable warrant before issuing of NBWA. That is my humble submission. And moreover, the honorable judge should have issued a bailable warrant or a summons before.
Initially, in non-appearance, did not issue any notice.
No,
No,
Your
not issued any bailable warrant.
No, Your Honor. And even his
It was
bail,
in the first instance,
yes,
NBWA.
and there were dispense petitions also filed. And on one occasion, dispense petition was entertained, but on the second occasion, the learned judge issued NBWA straight away directly without issuing a bailable warrant.
On 30th, did you appear?
If Your Honor will kindly look at page 121, order dated 7/7/2023. Out where it
Page?
says 121.
What is that?
Accused persons, namely Saiful Islam, Ashradul Ali, and Kamaluddin and Appu Venia are present. He was present on this day. He was present on this day. 17/7.
On 17/7, he was present.
Yes, Your Honor. Thereafter, Kamaluddin.
Present.
Thereafter, on the second day, that is on 15/9/2023.
He remained absent.
Here also he was present. Accused
On
person
15 also
named
he was present.
Present. Second line.
Okay.
After that, Your Honor, on 30/10/2023, accused person, namely
Next day was
Kamaluddin, are
30th.
absent with steps. So this day his dispense petition was allowed. Thereafter,
Where do we find that petition was allowed?
at para number 3, Your Honor,
Yes.
seen petition number 480/2023 filed by Learned Counsel T.N. Minto for accused Kamaluddin. It is informed so and so, and however it is prayed that personal appearance of the accused person may be dispensed with for today. Heard and prayer is allowed. So on this day it was allowed. Thereafter, on 12/12/2023, he was absent. So on this day, the Honorable Judge had issued NBWA.
He shall produce medical certificate regarding his ailment. Yes, then thereafter,
Thereafter, on the next day, 12/12/2023, this is the
12/12.
impugned order, Your Honor. On this date, the NBWA was issued.
no, because in the earlier date you remain absent and you were supposed to produce the medical document. Neither you produced medical document nor you appeared. That is why issued NBWA.
But he appeared on the on 8/4/2024, and also, Your Honor, there's
No, on
the
30th.
procedure.
38. 38. On 30th, you remain absent without any steps.
With steps, Your Honor.
Hmm?
Third paragraph, seen petition number 480/2023 filed by Learned Counsel so and so for accused Kamaluddin. On
That is
this
for
day, dispense
that is
petition
for
was filed
Asadul Ali.
for Kamaluddin, Your Honor.
Hmm?
Para 3 of page 123.
Okay.
Para 3 of page 123.
That is on 30th.
30th.
Yes, kindly read.
Seen petition number 480 of 2023 filed by Learned Counsel Mr. T.N. Minto for the accused Kamaluddin. It is informed that accused is suffering from ailment and could not appear before the court today for hearing. It is prayed that personal appearance of the accused person may be dispensed with for today. Heard and prayer is allowed. However, it is ordered that accused person shall produce medical certificate regarding his
produce
ailment
medical
next date.
documents, certificate,
Yes, Your
isn't
Honor.
it?
On the next
Then
date,
He did not appear.
on the next date, Your Honor, he could not appear because he could not find a vehicle, or his vehicle broke down on the way in Tenga on the way to the court.
Where is it? Where is in on record? It has revealed that his vehicle. It only says Kamaluddin absent without any steps.
Your Honor, on this day, Your Honor, the counsel for the accused person was present. However, it appears that there's no such record that has been recorded.
Now he is inside the custody.
He's inside the custody. He was arrested on 8th April 2024. The day that he appeared before the court, he was arrested.
Why don't you
and
file bail
arrested.
application there?
I had filed for a bail application. However, there was a discussion with regard to this issue that if the accused person is still on bail, his bail was never cancelled, Your Honor. The bail was granted by this honorable court, but it was
No, that
never
is different.
cancelled.
That is different. The initial stage, he was granted bail,
Yes.
but this is for his non-appearance for trial. This is different,
Although
altogether different.
Even for that, Your Honor, if he's being arrested, there's a procedure under CRPC that has to be followed, that he has to be at
No,
least
he did
given a
not appear.
notice.
He did not appear.
But before
In
cancellation
first
of,
instance, he did not appear. He made a prayer on medical ground. He was allowed and directed to produce medical document. On the next
And-
day also,
and
you
he
remain
had-
absent. That is why.
he produced the documents later on when he appeared.
Where do we find that?
The, at page 130 on, 130. He had also applied for bail before the
No.
learned judge, and he
So on
had
the next
annexed,
date, I'm saying, on the next date,
on the next date, he
130
did
is
not.
different. 130
Is a bail application that he had
okay.
applied
So
along
this
with
bail
all
was
the medical-
rejected.
Yes, Your Honor.
When it was rejected?
On 8th of April itself.
You filed subsequent bail application then?
Your Honor, I had filed for bail application, and it was listed before Honorable Justice Shushmita.
How that can be quashed? How this order can be quashed? Because subsequently also on your non-appearance, then not only one NBWA, but then subsequently also it was issued. How that can be?
You know, the Honorable Supreme Court is very clear on the issue that
I think you better file bail, subsequent bail application. The situation has changed. So this bail when it was rejected, you said? The first bail application on 8,
the bail application was
where is the
rejected.
rejection order?
Page 143. On
143.
3rd of May, 2024.
What is the ground taken by you in this bail application? Bail rejection order page 1?
The ground was that he's still in need of some medical
No,
attention.
the bail
He has
rejection
not
order
recovered.
page
143.
143.
4 kg brown sugar was recovered from his possession.
So he's involved in commercial quantity.
Yes, commercial quantity. And he is in para 3, it is observed that he is a habitual peddler,
Involved in more than one case. So many cases.
and medical document doesn't show any serious ailment. It's only cough with chest pain and headache.
By not appearing before the court, you have also violated the bail condition, bail condition of the High Court also.
Your Honor, even then, the accused person was granted the liberty
On
by
that
this
ground
honorable
also could have
court.
been cancelled. Found absent on several occasions. Without any step, that is also. No, question will be difficult here in this case. No case made out for crossing. This crossing petition.
Yes, Your Honor.
May be dismissed.
Your Honor, I
Yeah.
may be allowed to submit a few judgments.
There's also settled position of law that non-bailable warrant of arrest can be issued directly also without.
No, he knowing that the case has been fixed, he remained absent.
Yes, and he was.
He had remained absent because he was unwell, Your Honor, and the medical certificates he had also annexed it. However, he had made efforts to appear before the honorable court on 8th of April, and he was there before the judge.
No, the NBWA was issued when you remain absent without any steps, no medical certificate. And the first day also, you took the plea of medical ground, but then no certificate. Next day also, you did not appear, no steps.
Also, Your Worship, Honorable Apex Force in pattern of decisions observed that incarceration period is no of material when there is a prima facie case established against the accused persons. Incarceration period is of no materials. So this petition may be dismissed, Your Worship.
In that case, Your Honor, I may kindly be granted some time to bring some case laws before this honorable court in support of my submissions.
You file objection then? No case actually made out here.
Yes,
You should actually withdraw the case, even if it proceeds, it won't help you. Better withdraw and file bail application, subsequent bail application.
Your Honor, if Your Honor may kindly.
Bail can be considered. If you have a medical ground, on that ground, bail can be considered. No case.
Your Honor, if Your Honor may kindly come to page 21, para 28 of my petition.
Page 21.
21. I've mentioned here that file for a bail application initially, BA number 54 of 2024.
Page 21, para?
28.
Yes, what is that?
There was a bail application that was filed, Your Honor, BA 54 of 2024. However, the same was withdrawn and then criminal petition was
Bail
again
application filed before
before this honorable court.
this court.
Yes, Your Honor. It was withdrawn because there was a question with regard to whether if the bail was not even cancelled, then whether the whether this honorable court
That
can
was
grant-
in the initial period when you were arrested.
No. This
So
was
this is
initially, Your Honor.
this time you have been arrested on violation, for non-appearance. That is on the basis of, on the strength of the NBW issued by the court only. This is different. That bail is for in initial period, but this has been arrested for some other ground. Again, different ground.
Exactly.
Why you can't lie? Because this time you have been arrested because you did not appear. Earlier bail stands only. It's not connected with that.
Violation of bail
But the
conditions.
liberty was granted
Yes.
by
Violation of bail conditions.
Violation of bail condition also, but then not on that ground. Violation of bail condition, that bail has not yet been cancelled. That remains only. But then this has been here, this time you have been arrested only for non-appearance and on the strength of the non-bailable NBW issued against you for non-appearance. So this is altogether different. Bail can lie. It's better you file bail application because this, in any case, NBW not only once, the first one, even if it goes, because first time the learned court should have issued the bailable warrant first. If that on that condition, if that goes also, the next time then second one, third one, fourth one, third one, then
only on the second occasion he was absent, Your Honor.
Hmm.
Thereafter he had
No.
appeared.
no, because the first order, you remain absent and on medical ground without any certificate. You are asked to produce medical certificate on the next date, and on the next date you remain absent without any steps. Then on that
Your Honor,
ground,
the
the
accused
direct
person
court
also
will issue
travels all
NBW
the-
only.
The accused person also travels all the way from Assam, and in case of
No.
curtailing the liberty of the accused person, Your Honor, the honorable judge should have taken into
What
consideration
liberty?
that-
What liberty?
Because he was already
No, no,
on
no.
bail granted by this honorable court.
What about the right of the court?
And Your Honor, in the order also, the learned judge has mentioned that he has appeared
no.
only once in the entire.
Even
trial
if you
proceedings.
want to continue, we can issue notice, they'll file, but then it won't. You better file, withdraw and file bail application. We'll consider. Basing on the medical document if you have. What do you say? It will be dismissed only on the basis of the order, impugn order.
On 5 occasions, he remained absent.
Yes. 4, I have seen 4.
5 from page on 21.
Okay.
Date 17/7. 15/9. 30/10. 23/2. Oh, 4.
4 occasions. 30, 10. What do you say? You want to withdraw?
Your Honor, I may be given some time. Maybe this matter may be fixed on Monday for
But-
motion itself, if I may be
Please
allowed
pray
to.
for by
submit.
counsel for the petition. Release this matter again on Monday. Okay.
Deeply obliged.
Let us see. Let her come here if there is any.
Complex.
Thank you.
Please, Watson.
Yes.
My lord, in this case, petitioner is assigning the tender process initiated in pursuant to NIT dated 10th of October 2024. The ground of contention which is urged by the petitioner is that, my lord,
My lord, this tender process has been initiated in violation of clause 4.13 of CPWD manual, my lord. My lord, kindly come to page 22, my lord. Page 22, my lord. Clause 4.13, my lord. Clause 4.13, my lord. Time limit for. When this was, just a minute. Yes, ma'am. Page 22, my lord. This is extract copy, my lord. Okay. Of the CPWD, my lord. Just a minute. When the corrigendum was published? Corrigendum was published on, my lord, my lord, it was dated 10 October, but my lord, it was published on 11th October, my lord, in newspaper. Where do we find that? My lord, I have the copy of that newspaper, my lord. I have craved leave of this court to produce the same on at the time of. So counting from 11, how many days? My lord, 5 days, my lord. And
5
out of
days.
that, three days are my holiday. 11th is holiday, 12th is Saturday, and 13th is Sunday. And only remain 2 days, my lord. In 2 days, my lord, obtaining tender paper, they are just submitting it because my 15 was the last date for submission of the tender paper. Well, 2 days. So normally it should be 7 days. 7 days is for clause 4.13. Exclusive, 7 days inclusive of
Yes,
the
but
date of publication also.
Publication and my lord submission.
So actually, you got then only 5 days.
5 days, but out of this, 3 days are holidays. My lord, in 2 days, my lord, it is
Yes.
impossible.
Well, please come to page 19. One night.
Yes,
May I read, my lord?
yes, please.
In partial modification of this department by so and so dated so and so 9 October, which was published on 9 October 2024. First advertisement was issued on 9/10/2024. My lord. 10/10/2024 is the corrigendum, which is the continuation of the first NIT. My lord. So, my lord, by counting from 9/10/2024 till 15/10/2024, it's a 7 days, my lord.
My lord, that is right, man. I will clarify.
Just a minute, just a minute. They count, counting, they starts from
9.
9th.
Yes, my lord.
The time limit mentioned above are exclusive of date of publication, but inclusive of last date of receipt of tender.
My lord.
So it clearly it appears that exclusive of date of publication,
My lord.
the 9 goes.
My lord. But eventually, my lord, what happened, my lord, there is a subsequent development, my lord.
Okay.
My lord, the LOI, my lord, work has, my lord, this tender process has been completed, LOI has been issued, my lord. Now, my lord, he has to challenge the subsequent development, my lord.
My lord, I am
Because since
challenging the
now his
tender
interim,
process, man.
interim prayer, my lord, is become infructuous, my lord.
Is it?
Yes,
No.
my lord, because the work has been awarded. My lord. My lord, the petitioner is praying for, my lord.
Then their interim goes.
Yes, my lord.
No, my lord. My lord, if my lord pen has submitted some documents, my lord. My lord, my interim prayer is actually, my lord, in this petition, man. I
So
challenge
your prayer is also for
Page
not to
13.
finalize.
Yes, not to finalize.
yes, my lord. Interim
It was
prayer-
finalized.
Finalized, my lord. LOI has been issued, my lord. Letter of intent, my lord. Yes.
My lord, letter of
Work has been-
letter of acceptance. Thereafter, after letter of acceptance, they, my lord, they have to accept the offer, my lord. Thereafter, agreement will be done, my lord. Thereafter, proceed to work, order will be issued, my lord. It is not completed yet, my lord, in my humble understanding. LO is, my lord, initial stage of, but after this, minute set visit, my lord, prepare, my lord.
Subsequent development has to be challenged.
My lord,
What
that-
stage is
that-
called finalization?
Finalization, my lord. To my instruction, my lord, the tender has been finalized, my lord.
Finalized.
Yes, my lord. This is what I have been given, my lord. In case, my lord, this honorable court, my lord, requires more documents, I can produce, my lord. But the tender has been finalized, my lord. to my instruction, my lord. He has to file separate writ petition, my lord, challenging that subsequent development.
I'm challenging the, my lord, process of tender, my lord. My lord, I'm challenging the, my lord, root of
And-
this
and
tender process.
In
my lord.
case, my lord, the prayer, my lord. My lord, may kindly see the prayer, page 12, my lord. For his first
Yes.
prayer, my lord. He's challenging the entire NIT, my lord. When he is challenging the entire NIT, my lord, the other tender participants, they are necessary party, my lord. And this
Yes.
person, my lord, who has been
You have
awarded
not
this,
made party.
he is a necessary party, my
The
lord.
person,
Yes.
no, no, no. Who, then how he would
How
know?
can I know, man? Who has the participant?
It is there, my lord.
Hmm?
It is there, my lord.
Where?
In the, my lord, what I say, my lord, this instruction, my lord.
My lord, instruction, there may be
He
might
has
in
to make-
instruction, my lord. But
So now the new party has come probably.
Yes, my lord.
Now after finalization.
Yes,
Because
ma'am.
you have given it to some other.
Yes, my lord. They are necessary party now, my lord.
Now they have become necessary party.
Yes, my lord.
But then prior
And
to that,
behind
how
them,
would
my
he
lord,
know?
no interim order can be passed, my lord.
How many forms you have given?
My lord, for that I have to get the instruction, but this is the development, my lord. The LOI has been issued to some individuals, my lord.
3,
Four.
4.
Yes, my lord.
No,
Four
3 means
voters.
2 are same only, SP,
All right, my lord.
SP same.
They are necessary party, my lord. Let them amend
No.
their writ petition.
in my humble understanding, my lord, they are not necessary party, my lord. There might be some subsequent developments, my lord.
No, this
Yes, my lord.
after subsequent development,
Yes,
yes, which he has produced.
But my interim period is not to finalize
Hmm.
the tender process, my lord. In the meantime, my lord, I can, my lord, implement them. Or I can file a new petition on
But
subsequent
it
cause
says
of
that it
action.
has already been finalized.
Yes, my lord.
No, my lord. In my humble understanding, it is not finalized. Because only, my lord, letter of acceptance has been given, my lord. Thereafter, my lord, other 3 processes are there, my lord. Other 3 processes, my lord. Letter of acceptance will be given to the, my lord, this, who has been awarded, recommended by the standard selection committee, my lord. Thereafter, my lord, they will submit their, my lord, acceptance letter. Thereafter, my lord, agreement will be entered into. Thereafter, the order to proceed with the work will be issued, my lord. That is not finalized, my lord. There is altogether 3 more stages are there.
Okay. But Mr. H. Lampu, Learned Counsel for the petitioner. By filing this writ petition, the petitioner has a sale, the challenge the your impugn order is which one?
Process of tender, my lord.
Process.
Process of tender, my lord. Initiated pursuant to this, my lord, page 18.
Challenge the process of tender initiated. Right. Page 18 is
This the initial, my lord, initial.
NIT dated 10/10/2024,
Yes, my lord.
This is the corrigendum NIT, my lord.
Page 18 is-
issued by the Block Development Officer, Keneva, CD Block, white number CD stroke KWA stroke VVP stroke 2024-25, dated 10/10/2024, for care of multipurpose community hall within bracket Pakka bracket close at Beong, Walong, Saria, Taham and Langchu, PAHK Tahakang, EAHKANG and Langchu LANGCHU.
And page 19 also, my lord. Page 19 is corrigendum, my lord.
And the corrigendum. Dated 10/10/2024. This is also same. Issued by the block development
Yes, my lord. Same.
office, Caneva, same. Number is also same.
Number is same, but it was
This also-
issued by Joint Director RE, man.
The date is also same only.
Yes,
It
my
My
appears-
lord, this, my lord, this tender is, my lord, issued on such a hush manner, man. My lord, there is lots of discrepancy, my lord.
Paper publication malad cannot be termed as hush manner malad.
This is not publication. The paper of publication was 10th, and they have given this that 10th. Well, it is issued on 9th October, my lord.
It was an open competition malad. Malad may see the
Para.
side part of the.
It is submitted, it is submitted that as per clause 4.13 of the CPWD manual, the time limit for publicity of tender is 7 days in the case of work with estimated cost put to tender up to rupees 5 crore. Staff. The terms of the corrigendum dated 10/10/2024. The estimated cost put to tender is rupees 1 crore. And the time limit for publicity of tender will be 7 days. However, in the instant case, the corrigendum was published on
11th, my lord,
11th
October.
10/2024. And the last date of receipt of tender paper is on 15/10/2024. Thereby, the respondent authority has given hardly 5 days for obtaining the submission of the paper, or obtaining and submission of the tender paper. Stop it, tender paper. And further that out of those 3 days, out of those 5 days, 3 days are holidays,
Holidays.
being what? Sunday, Saturday.
So, my lord, the 12th is Saturday, 13th is Sunday, and 11 was, my lord,
12 Saturday, 13 Sunday,
Yes, my lord.
2 days only.
11 was also, my lord, a holiday.
What holiday?
11 was,
As per my instruction, we were available on 11 and 12 malad. 10, yes, malad, 13 there was a malad closer malad. But 11, 12 we were available.
let it be, my lord, so, my lord, 3 days, my lord. I will pay.
Okay, 3 days.
I forgot.
Well, holiday, huh? Stop. Thus, the respondent authority has violated the CPC manual. CPC manual 1.4
4.13.
violated the 4.13 of the CPC manual. Therefore, the said process, therefore, the process, the entire NIT process
Yes, my lord, is vitiated, my lord.
is vitiated and liable to be set aside and was start on. Issue notice, returnable by. Hmm?
1 week,
So
my lord,
that, my lord,
two,
in
Two
time,
weeks.
my lord, I will
Yeah.
protect them.
By 2 weeks, stop. Mr. Binter Picha, put it on. Since Mr. Binter Picha appeared and accepted notice on behalf of respondent number
1 to 3, my lord.
1, 2,
3. All the
and three.
respondents.
All the respondent?
Yes,
Okay, no formal notice need be issued. However, the petitioner shall furnish a requisite extra copy to the land council for the respondent during the course of the day's staff. Para. No, would appear in after Binter Picha, okay. Binter Picha would appear and accepted notice. Then Mr. Picha, land council for the respondent. In the at this stage, Mr. Picha, land council for the respondent produce. What is this document called?
letter of intent, my lord, LOI.
The letter of intent. No, submits that the matter has been finalized according to you,
Yes, my lord.
has been finalized and produced a copy of letter of intent within bracket LOI bracket close for letter intent. Three.
Four packages, my lord.
One is all the same, I think.
My lord.
SP Enterprise 2.
Yes, ma'am. But 4 different packages are there, my lord.
Different.
Yes, ma'am.
Okay. Issued to four different
Packages, my lord.
package
Yes, my lord.
to the
My lord, may see page 19, my lord. There are 4 packages, my lord. Page 19 of the writ petition, my lord.
okay.
Construct multi at Beong, my lord, 1 crore. 2, my lord, community hall at Walong.
Okay,
Second page.
so issued to the four different farms against the four different packages, stuff. Okay. Para, list is matter after 2 weeks. Then, prior to that, however, Mr. Lampong, land council for the petition submits that the case, the process has not yet been finalized. Okay. Para, then, list is matter after 2 weeks, stop, para. In the then if not finalized, we'll say.
Yes, ma'am. Yes, ma'am.
If not finalized.
Yes, my lord.
Okay. Having heard the land council for the parties and taking into account of the contention made in the petition, it is provided that if the fair process initiated by NIT dated 10/10/2024 has not yet been finalized, comma, the same shall not be finalized, no,
Yes.
not be finalized till the next returnable date.
Obliged.
Obliged.
Marvelous, ma'am.
Yes.
So, before the lordship, the present impugned LPC is challenged, which was passed on 18/7/19 and the order in 16/7/2019. Here, my lord, before come to the impugned order, what is the involving facts is that the Indian Army has occupied 49.63 acres of the land at Alo Township area. In the meantime, that has not so far been acquired. The land has not been so far acquired. So accordingly, the Indian Army has decided to acquire the land by paying the compensation to the person who are the landowners. In this regard, now that compensation is yet to pay. Therefore, now the controversy is between me, the petitioner, and this private respondent. Now, private respondents are claiming that that land belongs to them on the ground that they have obtained the LPC from the concerned Deputy Commissioner Alo. And my contention is that this LOC was issued to them before the notification of before issuing of the preliminary notification. Therefore,
What preliminary notification?
well, the preliminary notification was issued that the army is going to acquire this mass of the land so that whether any complaint has been made from the other private or not. Accordingly, I have objected that the army, I am also the landowners within that army occupied area. Therefore, I have objection against this particular person, that is my private respondent. Now, the claiming
You
of
have objected, private respondent?
yes, against the private respondent.
Why?
Now the
What
content,
objection? What kind of objection?
because that the land was not properly acquired
By?
by the Indian Army. And since
Why then you raise objection to the private respondent?
I am objecting to the private respondent only on the ground that the land involving of 49.63 acres is land of 4 villages at Alo, the 4 villages adjacent to the Alo area. But despite of that, those who were the committee, land boundary committee, they become the landowners. Therefore, against my objection, the deputy commissioner has against me that rejected my objection, and that is in the separate case in 492, WPC 492. That is another.
You raise objection to the private respondent saying what?
Saying that the LPC should not be issued to them in the
Against LPC issued
yes,
to the private
against the
respondent.
LPC
Say that.
in the casual manner. So I'll take the lordship to the page number 28, 29. My lord, what is page
This is
number?
my note.
29, this is my note passed by the deputy commissioner, whereby this has been attended by 20%, 20 members only. And out of 20 members, these 9 members is the private respondent. So what they said that this meeting, so this contention of the meeting is that these 9 members will be the name of the 9 members is mentioned here, and they will be the landowners. Therefore, in view of this order was passed on my lord 16/7/2019. Thereafter, I will track back to the lordship to page number 23. On 18, within a 2 days, in continuation of the order that the 16 July 2019, this order was land ownership certificate was issued to all these private respondents on 18 within the within 2 days, whereby this person has having this mass of the land. Therefore, while I am questioning against this land ownership, I have gone through from the record. I have inquired from the concerned deputy commissioner. My lord will find in page number 24 by asking that whether any procedure has been maintained to issue the land certificate to the private respondent or not. In this regard, my lord may kindly come to the page number 26.
No, just a minute. What you are submitting, you are not showing the paper. This 29 is the minute.
29 is the
is
minute,
On the year 2019.
19.
Then this page 23 is the land ownership certificate issued to 9%
9%.
on 18 July 2019 again.
19 out of
Now
the
your letter is dated 2023.
my lord.
What is this?
Be-
How do you
be-
explain?
because my lord,
It was long back in the year 2019.
exactly my lord.
Now you have submitted this application for seeking information only.
Now,
What kind of information you sought for in the year 2023
now
against the land ownership certificate issued in the year 2019?
exactly my lord. So this matter I come to know only in the 2023 only when objection was made, and since
What do you want? What
my
is your
lord will
prayer
find
then?
in page number 27.
What is 27?
This is the clarification from the respondent authority, office of the deputy commissioner, that they admitted that without any maintaining the procedure, this LPC land ownership were issued to this 9% out of the minute of 18/7/2019. My lord, 1, 2, 3, 4. I would like to read out, my lord, the same from the page now, second last para, page 27. As part of minute of the meeting held on 16/7/2019, the land ownership certificate by number such and such was issued to the submission of the army. The land ownership certificate is not a possession certificate where the totally different procedure is flawed and hence both should be mixed up. Further, in the application RTA number such and such, RTA dated 6/2/2023, there was no mention of the land ownership. Rather, it is released to issue the LPC land owners of the NOC issued by the Blaze Authority in the Army Authority. Hence, you are informed that documents sought by you are not available in the office. No LPC has been issued to any private party for the land owners under the occupied of the Army, 49.63 acres. Lastly, the case is not about the LPC, so the question of the following procedure does not apply, and the land ownership certificate issued on 2019 is the outcome of the public hearing conduct on 16/7/2019 with a unanimous consent of the members present, including the Blaze Authority public and the owners of the this PDBRATC is the Blaze named. Hence, the allegation against them, the deputy commissioner, to disburse the public money in the name of 9% hold no water. This is the
So this is only
clarification.
seeking information. What is your grievance?
Now, my lord, my main grievances is the order passed by the deputy commissioner against wherein my claim has been rejected. My lord, on the ground that until and unless the LPC in the name of these private respondents are not been questioned, not been challenged. Now this is their document. That is the main backbone document of the private respondent, that they have the land owner certificate. Therefore, my question is that for the public hearing, the notification was made on 16 August 2021, whereas they are showing that public meeting was already conducted in 2019, and out of the 2019 public meeting, these people become the landowners. So my question is that these, after the preliminary notification, only this public meeting could have held. At the same time, the public meeting which they are showing to me is attended by only the 20 members. 20 members, out of which these 9 is the private respondent. Therefore, this public meeting passed in the form of this minute by the Deputy Commissioner is challenged before the Honorable Court along with the
2019 minutes you are challenging before this court?
Yes.
Why?
Because without this, my lord, my further proceeding in this compensation issue is being blocked, my lord, on the ground that the claim now only.
Now, where you were at in the year 2019?
My contention is that
No, where you were?
I was there, but
When this minute was,
I have not been informed. There was no public notification because the public notification made in 2021. Till then, since 2021, I am there.
what is your right to claim about that?
Yes,
Challenging 2019 minute.
because the 2019 minutes of the 2019 was not done publicly, and I come to know only in the 2023 from the my lord, reply clarification from the office, concern office, that is
You
the
make a
office of
representation before the Deputy
Deputy-
Commissioner.
Exactly, my lord. I have filed a representation questioning about the LPC land ownerships, and what the reply said that no, this
No, no, first, what is your claim, your locus to claim, to claim against 2019 minutes?
my lord.
You are also laying on order.
Because
according
I
to
am
you.
also landowners, and within the proposed army, my land is also there within the proposed army occupied area. But I am kept in dark. I have not been informed. There was no public,
So everybody was aware of all those things,
my lord.
all
No,
those
this
development since
particular,
2019.
only the particular persons are only aware of my lord. Aware about this, my lord. These private respondent. Therefore, my lord,
Army is acquiring for what purpose? Already acquired.
that in fact army is already there, but no formalities of the acquiring has not been done till today. Therefore, the army is ready to acquire by paying the compensation. Now issue
Okay, you are interested in compensation
my lord.
after 2019. Now you have come.
When my lord, this was public notice was made in 2021.
Where is your representation and where is the reply?
My lord, that's reply in page number 27.
Where is your representation? Let us.
My lord, that the representation is, my lord, I admit that representation is not before that, my lord. My lord, that has not been annexed, my lord.
Okay, that you will annex after again 4 years.
My lord, that. Now, in such situation, my lord, my father claiming and my father, my lord, this claiming about the disputed land is, my lord,
Where
blocked
is
by
your claim? Where is your claim? Just one letter. Where is your claim before the authority in a district?
my lord, that.
Any claim.
Yes, my lord.
Where?
My lord, though not in this 489, but in 492, in the writ petition 492/22 is pending before this honorable court, my lord. That here also, my lord, what my claim is that I have also the land. Therefore, now
No, where is your-
ownership is yet to be decided by the deputy commissioner. Whether this
You must
land,
have submitted claiming that you are also owner of the land.
exactly,
Submitted some documents,
various,
some application, some representation against before the authority.
My
Where
lord.
is that?
That's all are, my lord, these all documents are, my lord, pending with the WPC number 492, my lord.
492 is also
492.
pending.
But what is
Similar
only the,
nature.
yes, 492 before petition number.
That was also filed by you.
Yes, ma'am. But what is remaining, that what I am
No,
questioning is,
what was the 492 about?
492 is, my lord, basically the order passed by the deputy commissioner,
Hmm.
wherein the deputy commissioner has rejected my claim, rejected my claim over the particular land that within the army occupied area.
Okay, then why this again?
Because of these two documents, the LPC land possession, land ownership certificate has been issued to the private respondent, and that was meeting out of the 2019 meeting, they
Now,
become the
now
landowner.
see, you have no case. You have no locus, nothing, no records here. How do we entertain?
My lord, till today, my contention is that until and unless,
No, till today, you have not, where is your claim? You have not made any claim till today.
my lord,
Where
that,
is the claim?
that claim is, my
Then-
lord, I have already filed before the deputy commissioner.
So
That
who
everything is
prevent
clear.
you, who prevent you from annexing here also? To tell the court, to satisfy the court that these are the claim that you have made.
My lord, that is there.
Then
But
otherwise you say nothing.
otherwise, my
There
lord,
is no documents at all. Where is the document?
otherwise, may I suggest, my lord, this matter may be listed together with 490, WPC 492 of 22. These are all similar matter. Here, I am particularly question only this two order that is against the LPC, my lord. When the deputy commissioner has accepted that the LPC was issued, therefore, my question before is that LPC was not properly issued and this should not be considered. Therefore,
Here, what is the challenge?
challenge is, my lord, in page 23, my lord. How, my lord, this landowner certificates can be issued in such a, my lord, casual manner.
So you should file before the deputy commissioner.
Exactly,
For
my,
cancellation.
what I am contending that I have already filed before the deputy commissioner.
Where is that?
But the deputy commissioner has, my lord, rejected that until
Where is
and
that? Where is
unless
that letter? That letter
this
is not there.
LPC is
No,
not
no.
challenged, man.
Hmm?
Until and unless this landowner certificate is not challenged, it's become the, my lord, this absolute document. However, this was not issued particularly. Therefore, my question is that without maintaining the procedure of obtaining the land ownership certificate, this was casually issued by the deputy commissioner within the 2 days out of the meeting dated 16 July 2019. And therefore, I am challenging the order of the 16 July 2019, wherein the meeting
You
was.
have to satisfy, Mr. Modi, you have to satisfy that
I-
how you are aggrieved by this and what you have done if you are aggrieved. Unless that is satisfied, how do we entertain this?
To the extent, my lord, I am agree to.
At least to satisfy the court that you have raised objection to the issuance of this land ownership certificate or LPC to the private respondent. Then you have to show this court that you have made a proper representation before the authority, the competent authority, and that was not considered, and hence you have come here. You have to satisfy.
My lord, to the
Against this, straight away, how can you come?
My
You
lord,
are not showing your locus. You have no right at all. You
My
have
lord,
not
I
done
am agreed
anything
with-
to show your right.
I am agree to the extent, my lord.
Hmm.
But therefore, my lord, may I, my lord, pray that this
I think better you
this
withdraw
matter
withdraw
may
and
be
file a
minor.
press.
listed with 492, my lord.
No, because
Because-
here, without
What my contention is everything.
without substantiating with any documents, you are claiming against some other person, somebody whose document is also incomplete. You cannot. You have to satisfy. I think it will be better you withdraw and file afresh with annexing all those, and then you can make prayer to list along with those. along with the WPC. Here, I don't see anything.
All this matter.
Because we
With
have to satisfy the court.
Liberty matter.
Hmm.
So,
Yes,
always come with
Mr. Modi
more documents.
wants to withdraw this writ petition with liberty to file afresh. The prayer is allowed. Please, prayer is allowed. This writ petition is dismissed on being withdrawn with liberty is prayed for. Oh. Basic document you annex it is.
May I please, Lordship?
Yes.
Lordship, the petitioner before your Lordship is challenging the impugned transfer order, whereby petitioner has been transferred out from Karle, Government Upper Primary School, Karle, within 7 days, Lordship. And this impugned transfer order has been issued in violation of the transfer and policy guidelines, prepared and strictly followed by the department, Education Department itself. So may I take you to the first transfer order, where I have been posted to present posting place, Lordship.
Okay.
At phase number 17, Lordship.
Okay.
This is the first transfer order.
28 August. Okay.
In the interest of public service, so and so.
Yes, yes. Okay.
Petitioner,
abstain.
yes. Government school Gating. The petitioner, while he was serving as a PRT at Gating School.
What is this PRT?
Lordship,
What is this PRT?
primary teacher.
Okay. Primary?
Teacher.
Okay.
Primary school teacher.
Okay.
He was serving as a primary teacher at Government NSCBAV School, Gating, is hereby transferred and posted from Government NSCBAV School, Gating to Government Upper Primary School, Karle, under Monigaon Circle. Now, this is the initial my transfer order. By this transfer order, I have been transferred and posted to Karle, UPS Upper Primary School, Karle, Lordship.
Okay.
Accordingly, Lordship, page number 18.
Yes.
I have been released by the headmaster.
Okay.
And then page number 20,
Hmm.
I have joined here by submitting my joining report, Lordship. I have
Okay.
joined on 12, Lordship.
Okay.
Thereafter, Lordship, page number 21 is the impugned transfer order.
Okay. Where is your name?
Issued on 19. My name is at Lordship, page number 23, serial number 70, Lordship.
70.
770 serial number, page number 23.
Okay.
Here, Lordship, 70 series Jarbokomi, PRT, guessing, and I have been transferred to at the disposal of DDSE Tirap District, Lordship,
Okay.
within 7 days. Now, Lordship, may I take you to the guidelines? How this transfer or the impugned transfer has been issued in violation of the transfer posting guidelines. Here, Lordship, one thing, page 23, it shows that I was transferred out from Gating, whereas I have already joined in terms of pursuant to earlier transfer order. I have joined a Karle school. But this impugned transfer shows that I have been transferred out from the Gating.
So who issued the earlier order? Director,
DDSE, yes, Lordship.
Deputy Director. And who
Yes,
issued the next one? The impugned order?
Is Commissioner, Lordship, Education.
Whether the DDSE has a power and authority. Is he the
DDSE, yes, being a controlling authority within district.
whether your transfer issued by DDSE was approved by the commissioner?
Approval, Lordship. There is no such procedure for approval of my transfer since I have.
Yes.
I'm appearing on behalf of Tita Gum, Standing Council for Health Department, Education Department. May I pray that this matter may be listed on 4th, because he is not here today.
So on 4th,
Monday.
Monday.
4th. Because this matter I am not aware of.
Is it okay for you?
So, Lordship, no problem.
Okay. This is on Monday. No?
May I please, your Lordship?
Yes,
Lordship, this is a land acquisition matter of government land. Lordship,
item six,
Uh,
sorry.
the petitioners
Yes,
are allottees of government land. This is Lordship, there is a market called Lower Market in Ingyong.
Mm.
In that, there is a small road, and for expansion of that road, land acquisition, not only that road is connecting the highway that is coming from Pasigat via Mariam, Ingyong. Then that road will be joining towards the other bank of the river. So for expansion, it is a continuation of the national highway. For that, the portion of the lower market in which the petitioners are having land, this is sought to be acquired. Now that road, that place, except for the lower market, the rest portion of the land are private land that we are not concerned with. What we're concerned with is we are the allottees of the government land. Now because there is a very old road, must have been built around 60s, 70s like that. There are shops there. Since it is a market, buildings are already there since long time back. Now for expansion of that road, some portion will be taken. So the deputy commissioner had carried out verifications, but the deputy commissioner did not inform us, the land allottees, shop owners, saying that this is a government land, so you're not entitled for anything. But my contention before the deputy commissioner and also before this honorable court is that since the lease period of the allotments are still subsisting, the buildings are already there, damage will surely be done. If it is a national highway, then your lordship knows the right of way will be much more. The road at present is only about maybe 3.5 meters or so. Now, and in this case of expansion, it will go at least till 10 meters. The shops will be destroyed. So therefore, we had made several representations before the deputy commissioner. But on the verification, even the verification report has not been given to us. But one verification report is shown in which the chainage of the road, which is covering our spaces, are simply written as government land, saying that will not be given anything. So therefore, we are before this honorable court. Now, in terms of the law, Lordship, I'm placing reliance on I've already given the list of books. In the Prasad versus Union of India, para 5. I'm coming straight to this because, Lordship, in this case, what was said is, suppose a government land is given on lease to a private party. What is how compensation is to be determined? In para 5, what the Honorable Supreme Court has said, for example, it's an agricultural land. For example, there is nothing built on that land. And there is a condition in the allotment order or the lease deed, whatever is there, itself that if the land is required for public purpose, it will be taken back. In such a case, of course, since the government is the owner of the land, the person cannot have a right over any compensation that is to be paid. But in cases of this kind, in which there is a leasehold, and in the covenant of the lease, there is nothing written, whether if it is required for public purpose, this will be taken back or not taken back. These things are not there, and the person has already made investments on that land. Then in such a case, it has to be shared between the amount of compensation. The government simply cannot take back the land, saying that this is, even though you have built something here, this is our land. That cannot be done. Compensation has to be between the lessee and the lessor. There has to be divided. That is what. So I'm claiming compensation not only of the damage which will be caused to my properties, also the land. These two things I'm claiming. Now, Lordship, para 5, Lordship. It's a very long one. That's why I'm not reading out. This was what was held in this case. At page 242, in the middle part, 10th line.
10.
10th line
Okay.
in page 242. Take a case where the government has granted lease of the open land with permission to the lessee to construct a building for his quiet enjoyment with appropriate governance, and the lease with permission and the lessee with permission constructed the building, and by complying with the covenants of the lease was in quiet enjoyment the self-same property when required for public purpose. The government cannot unilaterally determine the lease and call upon the lessee to deliver the possession. Therefore, the government is required to exercise the power of eminent domain by invoking the provisions under the Land Acquisition Act for getting such land. The collector shall have to determine the compensation towards the leasehold interest held by the lessee, if accessible separately, and determine the compensation. The lessee being the owner of the superstructure and the government being the owner of the land, if compensation is determined for both components, the same has to be apportioned between them. At what proportion the lessor and the lessee are entitled to receive the compensation has to be determined in the absence of any covenant in the lease for payment and in the absence of any specific data available to him. The collector has to determine the respective shares at which the compensation is to be apportioned between the government and the lessee. The course open to the land acquisition collector is to determine the total compensation, make an award, and make a reference to a civil code under section 30 for decision on appointment. This is what I'm relying on, Lordship. Now, Lordship may see the documents here.
Yes, please. To start with your allotment.
Yes, Annexure 1 series. In accordance with the names of the petitioners, I have annexed in serial wise. Lordship may see the validity also. The validity of petitioner number 1 is at page 30. This is 28/2/2025. Then the next one starts at page 31.
28.
Page 31
Okay.
is of petitioner number 2's passbook, land
Validity,
passbook.
where do we find the
Validity in the, this will be in the last page of
No, the petitioner number 1.
petitioner number 1, page 30. Page 30,
Okay.
25, 28/2/2025.
2000,
25,
31, 12. No,
28 to valid up to, Lordship will see, before the signature, valid up to 28, 28/2/2025.
Oh, page 30.
Yes, this is for petitioner number 1. Then petition number 2's passbook starts at page 31. Is validity,
Okay.
Lordship, all of them are around this also, Lordship. Validity is at page 33. This is also 28/2/2025. Likewise, Lordship, all their land allotments are valid up till now. Lordship may see all the documents. Since these are very bulky, but Lordship, all the documents, they are valid till 2025.
This was issued in the preliminary notification was issued in way back in the year 2022.
22, but till now, they have not finished anything. This is preliminary notification is on 27 May 2022. Till now, as per my instructions, no final award, not even a final notification has been issued. Then, Lordship,
It has not, since 22, not finalized.
yes, so far my instruction goes, it has not been finalized. Now, Lordship, I have also annexed the notification of the government this is showing the road width, length in case of state highway, major roads, district roads. This is at page 102. This is a notification dated 21/12/2015. According to this also, in the state highway, Lordship may see the type.
Page.
102, this is the notification.
Okay,
This is the specification. In case of state highway, what will be the carriage width? What will be the right of way? Now, if these are followed, Lordship, page 104 is a type copy. This will be bit clearer.
Space.
104, type copy of the same document. Lordship may see in the state highway, in plain area, in open area, it is the carriage width of the road is 7 meters. In built up area, 7 meters. Then for right of way, in the built up area of state highways, it is at 25 meters. Building lines, state highway 30 meters.
Where are you reading?
Lordship,
Building lines.
4. One, Lordship will see number 1, carriage with highway, with carriage way width.
Yes.
Here you, Lordship will see the number 1 state highway.
Hmm.
Then thereafter, in the rows, your Lordship will see in what would be the width, what should be the width.
Yes.
In case of
7
state
feet.
highway, in built-up area, it's 7 meters. We are taking the built-up area because this is an area in which it's a marketplace. In built-up area, it's 7 meters. That should be the carriage width. Then Lordship will see Roman 2, formation width. Formation in case of state highway, it is 12 meters built-up area. Then Lordship will see the Roman 3, right of way. In right of way for state highway, if it is an open area, this should be 30 meters.
Okay.
Then in case of built-up area, in our case, it will be built-up area, 25 meters. Then setback distance, in cases of state highway, 2.5 meters.
Okay.
Then building lines, again, it's 30 meters. Now, Lordship, our main problem is, Lordship, our main problem is not that we are not going to give land or that that is not the thing. We are kept in the dark about these things. Even when the verification is given, verification is done, no public notice has been issued to us. This public notice has been issued only to private persons who are beyond that point of land. So we have no way of knowing how much of the land is going to be taken, how much of our buildings will be damaged. This also we have no idea because we have been making so many communications. We have personally gone and visited the Deputy Commissioner's office. But what they're simply saying is this is government land, you're not going to get anything.
Let us see one of your representations if you have submitted.
Yes. There are so many representations, Lordship.
Okay. One which you think is most important.
Lordship?
One.
Yes,
Let us see.
112 onwards. Almost all on the same lines, except for the dates. $112 is the
Yes.
first representation. Then starts at 115 substantially because we had,
What claim you have made here? Let us see the content.
yes, 115.
Relevant. No,
With
just
due respect,
say 112.
no, Lordship, we have submitted the second representation saying that we have superseded our first representation. That is why I'm directly saying 115, yes. With due respect and humble submission, we would like to state the following points related to proposed two-lane road from Lower Market, Yingyong to Moing for your kind intention and prompt action, please. Previous properties assessment survey of PAFs of Lower Market, Yingyong may kindly be reviewed. A joint meeting may kindly be arranged between PAF Lower Market and BRO authority, preferably an officer in the rank of either executive engineer or superintending engineer. Number 3, PAFs of Lower Market Yingyong will fully cooperate with government as proposed for two-lane highway. PAFs of Lower Market totally object to the proposed extension of 3 meters each or from both sides of the market road. The two-lane standard must be maintained as per government rules, guidelines. Then Lordship will see 116. It's almost the same, except for the dates. Then Lordship will see page 119. This is the third one. This is also same. Then 120. This is also same.
Okay.
Then 121, Lordship, is important. We have been, by this time, we have been told verbally that we will not be paid any compensation because it is a government land. So therefore, we made this representation. This is 25/8/24. Respected sir, with most disheartened appeal once again to your esteemed office that we, the project affected families of Lower Market in Gyeong, have always been seeking your good governance by writing many representations to your esteemed office for the better development of two-way highway lane highway in Lower Market, but our representation has been unheard and unnoticeable from your end. We, the PAFs of Lower Market, also put RTI regarding two-lane highway in Lower Market as to how the second two-lane highway is going to be constructed in the area that our respected PIO the LRSO has failed to furnish to us the DPR and other important documents asked regarding the two-lane highway. The following points are known to POs and be discussed. For no compensation of assets in Lower Market in Gyeong, certified true copy of DPR and survey report of two-lane of Yingkyong Moying Road 0.00 km to 0.39 km.
So what
Certified.
will the, yes,
I'll be appearing, my lord, for number 3 and 4, my lord.
okay, will issue notice?
Yes, lordship. And lordship, since till now, even the award has not been passed. I'm not claiming for the whole land. For the change from 0.00 to 0.839, that may be stayed for the time being.
What about the others? In respect of others, has it been paid?
Lordship,
In respect of others?
in respect of others, we have no.
Whether the compensation has been paid or paying?
Some are objecting, some have been paid. I don't know about, but what I do know is that final notification is not there, award is not there. And there are some people who have been rejecting the compensation, and I'm told 1 or 2 people have received the compensation. Since this is under JLR, it must have been done informally. That also can be said. But so far as we are concerned only with change number 0.00 to 0.839. That is the Lower Market.
Ms. Nikita Duncan, Land Counsel for the petitioner. Your basic challenge is
Lordship,
your
refusal and non-transparency in the matter of land acquisition for the purpose from change number 0.00 to 0.039.
where is the refusal order?
Lordship, the change.
Where is the refusal order? You
No,
said
no,
ref-
they have verbally refused, but Lordship will see one important document, Lordship, page 153. 153.
$53.
Yes, 153.
No.
This
53.
is the 153, 153.
Okay.
This is the verification report. Lordship will see in the first row. Has a Lordship found? First row
Yes. What
in the
is that?
table. The change number 0.00 to 0.839. This has been marked as government land in the verification
So your
report.
land falls under this.
Yes, other people, the rest are private persons. Theirs have been listed for compensation. This is the verification report.
You are aggrieved by this.
Yes. Although they are saying there is no verification report and this is not the final one, they are saying that, but as part of this, and they have told us also verbally that since this is a government land, we are not going to pay you anything.
The petitioner is aggrieved by the impugned verification report of Yingkyong Moying BRO Road within bracket 0.00 km to 4.50 km bracket close. by the district authorities. District authority means
Deputy Commissioner,
for the purpose of
Deputy Commissioner in Gyong.
by the district authority for the purpose of compensation in so far as the petitioners are concerned. That is change number 0.002 to 0.839 on the ground that the same is illegal and arbitrary, and on the ground that the same was issued illegally and arbitrarily.
Yes.
Okay. Issue notice, returnable by 4 weeks. Stop. Miss Momo, you are for?
Land management manner.
Okay. Appeared and accepted notice on behalf of the. Who is for
3 and
respondent
4.
number?
3 and 4.
3 and
4.
4. On behalf of respondent 3 and 4. Okay. And Mr. Appearing on behalf of Mr. Okay. Standing counsel for land management. What do we say? Land management. Also accepted notice on behalf of the respondent number 1 and 2. Okay, there is a pro forma respondent also.
Yes. This is the Bureau authorities. We have served a copy to Mr. Kato.
Okay, then we'll say that, since Mr. So-and-so appear, first 1 and 2, Mr. So-and-so appear on behalf of Mr. D. Kamdal for land department, and Ms. Wang Mo on behalf of 3 and respondent number 3 and 4 has accepted notice on behalf of the notice on behalf of the respondent number 3 and 4. No formal notice need be issued. However, the petitioner shall serve requisite extra copy to the land council appearing on behalf of the respondent within 3 days. Okay, stop. The petitioner shall also take steps upon the pro forma respondent number 5 and 6.
Lordship, since Mr. Kato is representing them, standing counsel, this is the central government.
He's not there.
We have served a copy to him
You have
yesterday.
served copy.
Yes.
Okay. Miss, then Nikita submits that a copy has also been furnished to serve to the respondent number 5 and 6 in view of the above. No formal notice need be issued to the said respondent as well. Stop. Para. Least is matter after 4 weeks. What action the deputy commissioner has initiated now
Deputy Commissioner,
with regards to the Chinese?
till now he has not done anything yet. But the road construction may start anytime. We have no idea about that. Because once that is started, then there will be no way of assessing how much properties were destroyed, how much could have been taken.
Then you see, we'll pass order in the interim on the next date. Interim prayer, okay.
Lordship only till the next day, Lordship. Lordship may review the order if Lordship feels so, but now Lordship may, because now is the winter is starting, so your Lordship knows in whatever is done is in construction activities are usually started in winter.
So that will be subject to the outcome of this writ petition then.
No, Lordship, what I'm saying is, Lordship, there are properties already there. We don't know how much of that land will be taken. If the damage is already done, there is no way of making the assessment, Lordship. Backdated assessment cannot be made because it is a question of structures, Lordship. That is why.
Okay, having regards to the contention made and the submission made by the Learned Counsel for the petitioner. Actually, you have also not specifically mentioned the action of the Deputy Commissioner.
Lordship. I'm saying the acquisition process so far as the petitioners are concerned.
Okay.
Only so far, only with regard to change number, which I have mentioned earlier.
Stay would be little difficulty.
Lordship.
Stay would be little difficulty.
Lordship only till next date. Lordship may decide otherwise also next date, but now Lordship may, because if everything is done already, it will be difficult, Lordship. Suppose they decide not to do, suppose they decide to simply take it, then it will be a
You are
problem.
only agreed by the verification report.
Yes.
Then how do we stay?
The verification report, because they are saying no compensation will be paid to us because it's a government land. So that means whatever structures are destroyed, that will not be part of the assessment.
Only say, well,
That will
for the
not
time-
that will
for the
not be
time
part of the assessment, Lordship.
subject to the outcome of this writ petition.
No,
Because
Lordship.
straight away, stay would be difficult
Lordship, only to the
because you
extent
only agree by the verification report.
because of the verification report, Lordship may hear, Lordship, because of the verification report, our land
And
is.
you have filed representation against this verification report only.
Yes, Lordship. That is because
That
Lordship,
the deputy commissioner will dispose of your representation, not yet disposed of.
the Deputy Commissioner has not entertained considered my representation at all. He has not even tried to dispose of the representation. Lordship, what I'm saying is, Lordship,
Have
the
you made a prayer-
verification.
Have you made a prayer to just dispose of your representation?
Yes, we have made that
Where?
prayer also.
Where?
Lordship, prayer number E,
E.
page 21.
So the pending disposal of this writ petition, there shall be no bar on the authority to dispose of the references dated 2/12/2022, 12/12/2022, 26/1/2023, 25/8/2024, and 19/9/2024 in accordance with law. We'll say that, and then the interim prayer shall be considered on the next date.
In that case, Lordship, a short date may be given because the.
Okay,
Uh,
then
big-
3 weeks.
Lordship, 2 weeks, Lordship, because
Okay, 2 weeks,
the
2 weeks.
respondents have already
Within 2 weeks
taken.
then, huh? Okay.
Obliged.
Yes.
Please, my lord.
Yes.
My lord, I'm agreed with the impugn transfer order dated 22 October 2024, my lord. which my lord will find at page number 19.
Yes,
May I read it, my lord?
yes, please.
In the interest of public service, the governor of Arunachal Pradesh is pleased to order the posting of Sri so and so newly promoted to the post of executive engineer as executive engineer, Tribunal PW division against Sri Tajum Nyodu. Tajum Nyodu is the petitioner, man. Executive engineer under Arunachal Pradesh Public Works Department with immediate effect. The posting of Sri Tajum Nyodu, executive engineer, is being decided shortly. Now, this is the impugn order, my lord. I am challenging this order, legally and validity of this order, ma'am.
The posting of Sri Tajum is the petitioner.
Yes, my lord.
Okay.
Now,
He has been posted to,
he was posted at Trigino. Now, in his place, the private respondent has been posted.
okay, now where he has been posted now?
Now, that I'll come to later on, my lord.
Okay,
Now, my lord, this is annexure 1, my lord. My lord, may come to the next page, my lord, page
No.
20.
Hmm.
Now, this is an order dated 17th January 2024, ma'am. May I read it, my lord? In the interest of public service, the governor of Arunachal Pradesh is pleased to order the transfer of Sri Tajum Nyodu, executive engineer from CE division to Trigino division newly created as executive engineer against existing vacancy with immediate effect till further orders. Now, I was posted to my present place of posting on 17 January 2024, my lord.
present posting,
Yes, my lord.
17 January
Yes,
24.
2024. And this impugn order is been issued on 22nd of October 2024. Meaning thereby, my lord, I have not yet completed my tenure, my lord. I was serving only for 9 months, my lord.
Okay. Now, is it compulsory to complete the tenure?
No, no, he has not completed, my lord. Why? Because, my lord, at normal tenure
It is compulsory to complete the tenure, what I'm
so
saying.
therefore, I'm coming to that, my lord.
Okay,
Now, thereafter, my lord, I have filed a representation, my lord.
okay,
Now, if my lord comes to the circular, my lord, which is at page 22.
okay,
Page 22, my lord.
yes,
These are the circular guidelines, my lord. In inviting a reference to the government order dated so and so dated 2nd of June 1998 and amended order dated so and so 19th 12/2008 regarding policy guidelines on transfer and posting of all categories of officers and staff under the government of Arunachal Pradesh, it has been observed that departments are not following the guidelines surreptitiously. Hence, the efforts of transfer posting policy are related for strict compliance of all departments. Further, it is hereby clarified that in terms of the guidelines under reference, the normal tenure of posting for all categories of officers and staff is 2 years. This order was passed on, circular was issued on 18th of August 2021, my lord.
who issued the first order? Your
Principal Secretary, my lord.
principal secretary, and who issued the
Circular, my lord.
impugn order?
No, circular was issued by the then Chief Secretary, my lord.
No, the first transfer order.
Principal Secretary, my lord.
Okay, then the impugn order,
Principal Secretary, my lord.
principal secretary,
Yeah, PWD.
the same,
Same, my lord.
maybe because of the administrative exigencies?
Therefore, my lord, in my humble submission, my lord,
Yeah,
transfer and posting is a incidence of service,
Yes.
my lord. I don't have a specific right to say that I have to be posted in this particular place.
yes.
But there are certain guidelines, my lord.
Mm.
Why were those guidelines enacted, my lord? It was circulated, my lord, to safeguard the officials, my lord. Now, if
What about your representation
it has not been disposed of, my lord,
when it was submitted?
29th, my lord.
28,
Because I received the transfer order of very late, my lord.
recently.
Yes, my lord.
So why don't you wait for this representation to be disposed of?
But my lord, since the order was already issued on 22nd, my lord,
Who have to move first?
nothing has been given, my lord. And now, today, my lord, I have not annexed it, my lord. I've received an order, which I have, after filing of this writ petition, my lord,
Hmm.
I received an order dated 25 October 2024, my lord, where it says, my lord, I have been now transferred to the office of the PWD Western Division, Itanagar, my lord, which I have not annexed, my lord. Because I was not aware of this order, my lord, because it was issued on 25th. After the earlier impugned order was issued. My lord, in my humble
No,
submission, my lord,
the impugned order was issued on 22nd,
22nd,
and this was issued on 25th,
25th, my lord,
placing you before, placing you where?
at the Chief Engineer's Office, PWD Western Zone.
Okay. By the impugned order, no place of posting was given.
Yes, yes, no place of posting was given.
Okay.
Whatsoever, my lord, this is a subsequent order, my lord. This is a subsequent order which originates from the impugned order dated 22/2/2024, my lord.
Hmm.
Because if I read it, my lord,
Yes, please.
my lord, I have already seen the impugned order, my lord. Now, may I read the
Yes.
subsequent order, my lord. Consequent upon the posting of Sri so and so white government order dated 22/10/2024. This is the impugned. He's speaking of that impugned order, my lord, which I have challenged, my lord.
Hmm.
And in the interest of public interest, the governor of Arunachal Pradesh is pleased to order transfer and posting of Sri Nyajum Nyoru, the petitioner, executive engineer Trijinok, to the office of the chief engineer, PW Western Zone, Itanagar, against existing vacancy with immediate effect and till further order. Now, this is a consequent order, my lord, which originates from the impugned order, my lord. Whatsoever, my lord, even if this is not challenged, my lord, nothing changes, my lord. The position doesn't change, my lord.
Yes.
Lordship, this is the order which has been placed, Lordship. The impugned order, that is 22nd October, Lordship.
Yes.
By that order, the private respondent has been sent to the regional, Lordship, in place of the petitioner, Lordship.
Yes.
And
No,
their
no.
Lordship order has been made, Lordship. In
Yes.
respect of the petitioner, shortly an order would be passed.
Yes,
Lordship.
yes.
And subsequently, this order has been passed, Lordship,
25th.
by which, Lordship, the petitioner has been transferred to Itanagar Chief Office, Lordship, and which has not been challenged, Lordship. So the advice would be, Lordship, this writ petition may be disposed of. Sorry, we don't with liberty to challenge these two order together, Lordship. Otherwise, the petitioner is not.
I think in your representation also,
Yes, ma'am.
probably this, you have to mention that you have, by this subsequent order, you have been posted in Itanagar.
Because
So change.
that's what I'm saying, my lord. I was not aware.
And
Okay.
no, representation, it has been reflected, Lordship.
25.
Reflected.
In 25th order.
No.
25 is, I was not aware. That's what I'm submitting, my
No,
lord.
no, representation he has already filed on 28th. So
28.
here in 28 also, this 25th order has not been mentioned probably.
So therefore, the proper Lordship course would be, Lordship, this order also needs to be challenged, Lordship.
Yes.
Otherwise, by impugned order, 22nd October, the petitioner is not that aggrieved, Lordship. Because even if it's still, Lordship, by this subsequent order, petitioner has been transferred to Itanagar,
That
Lordship.
will remain.
He would be at Itanagar only. How the 22nd order will be?
I think you need to challenge.
No, my lord. I have not been released, my lord, as of date, my lord. Since I'm not released, my lord, I have not been released, my lord, from Tigino, my lord.
Not yet released.
After my release, I'll join. If so ever, but what the situation doesn't change, my lord. That's what, my lord, I'm submitting, my lord. This is a subsequent order which originates from this order, my lord. When the root goes, my lord, the branches does not make any sense, my lord. If you cut the root, my lord, the tree doesn't stand, my lord.
You are still agreed by this 25th order also. You are not, you don't want to go to Itanagar also.
But it is a subsequent order, my lord.
No, what I'm saying is now you know that you are, you have been posted at Itanagar.
Yes,
Still you are aggrieved.
This I can challenge by an additional affidavit, my lord. But first of all, my lord, the original order has to go, my lord. It has to be state, my lord. It may be state, my lord, and in the meantime, my lord, I'll come with an additional affidavit, my lord, challenging the 25th order, my lord. My lord, they could have already posted me. on 22nd, my lord. But what prompted them to transfer this private respondent in my place, my lord, without giving me a posting order, my lord, and that too in violation of the guidelines, my lord.
Then since you have already filed representation, what if we direct the authority to dispose of your representation?
In my humble submission, my lord, this is a sheer violation of the guidelines, my lord. My lord, I was inducted in the service in 25th of May 1989, my lord. I have given 35 years of my service, my lord. Now I'm 58 and a half years, my lord. I'm going to retire hardly within 1 year and a half, my lord. I've given all, and I don't have any stigma upon my service career, my lord. Now, as I've already submitted, my lord, transfer and posting is an incident of service, my lord. I don't have a specific right saying that I have to be posted in particular place, my lord. But there has to be certain safeguards towards a government servant, my lord. I've given it, put in
You
so
file
much of my
affidavit
service.
then?
Lordship, how the petitioner, Lordship, if the present impugned order is still, Lordship, how the petitioner will, Lordship, have a relief, Lordship? Because, Lordship, by this subsequent order, Lordship, the petitioner has been only transferred to Itanagar, Lordship, which is not challenged here in this petition, Lordship.
This problem you need to challenge in any case.
I will challenge it afterwards, my lord. But then,
Even if
but then this has to,
if
first
even
of
if
all, my
it
lord.
is granted, Lordship, the petitioner has to come to Itanagar, right?
I think you on Monday also you can file challenging this event. Because it will remain incomplete. And then your representation also probably
Yes, ma'am.
on the same day. Also referring this 25th order, that representation also need to be changed. Because even if we direct the representative to dispose of the representation also, this is incomplete again. Here also.
Representative, it may be a typographical
So,
mistake, my lord, because it is
Since
26.
you have not yet been released, better you file on Monday challenging this also.
But-
And at the same time, and probably representation also you file on the same day.
My lord, in cases of transfer and posting, this is the problem, my lord. My lord is well aware, my lord. What if?
I think you have, it
what if
appears
I-
you have a case. I
Yes.
think you come properly then.
That's the point, Lord.
Because,
That's
my
the
lord,
point.
The problem is, my lord, I was not aware of this order, my lord. Now, I
Now,
have
copy is
received-
available with him now. Just at least
Delay in latest,
It will
my
be-
lord,
it
in
will
the
be
transfer
better.
posting
It will be
case, like it will hamper the entire case, my lord.
It will be better. It appears. It will be
My
better.
lord, I agree with that, my lord.
Hmm.
But then, my lord, what I was of
Because
the, I was of the
now you
impression,
have a order in your hand.
I was of the impression that, my lord,
Hmm.
see, since a transfer and posting are made in public agency, my lord,
Hmm.
what prompted the government to transfer me out?
That is why you have case.
Yes.
You have a case. Hmm.
Let them, I was of the impression that let them call for the records, my lord. And so, what was the public agency, my lord?
Maybe something else, we do not know, but then,
Anyway, I'm obliged, man.
okay,
With the liberty, man.
okay, Mr. Opada, Ojingpada, Learned Counsel for the petitioner, want to withdraw this writ petition with liberty to file a fresh. Stop. The prayer is allowed. This writ petition is dismissed on being withdrawn with liberty is prayed for. Okay,
All right.
come back on Monday. Yes, yes, please. Sir.
After hearing of the item number 8, it will cover item number 29. These are the similar matter. However,
Item 29.
yes, however, matter pertaining to this transport issue. But here we are poor in them.
Yes.
We are poor in numbers. This is not matter pertaining to the transport, but we are here before the lordship as to why the transport orders may not be effected. On the ground that, my lord, the transfer order was passed by the Director of the School Education, Itanagar, on 13 August 2020.
Can the court direct?
On there is the region here in the region is that we have already been released from the respected school by the headmaster of the school. But what is working is that the particularly respondent number 3, the deputy director of the school education East Kameng district has not released the service book.
Okay.
And since the matter is the inter-district transfer, the service book along with the final recommendation is required from the deputy director of the school education, SEPA. And because of that, till today, despite that we have been released on 21st September 2024, still we are in the pendulum. We are
September,
yes,
only 1 month.
we are ready to join to our new posting place.
You have not yet joined.
My lord, on the ground that the service book has not been released and that the matter
Service book will be released subsequently.
and
It will be
definitely
released
that
subsequently.
can be, and at the same time, my lord, the final recommendation is,
You want to carry the service book along with you.
my lord, final recommendation is required from the, my lord, deputy director of school education from the concerned district. And that is why, my lord, we are not in position to join to the new posting place. Therefore, my lord, let the notice be issued and let the notice be issued upon respondent number 3, my lord.
Let us see your prayer. What is the prayer?
In page number, my lord, it is start from 11. My lord, got it? In circumstances, and most humbly fetch that the lordship would be pleased to admit this.
No, your prayer is to release the petitioners.
My lord, as to why the direction shall not be given to the
No, whether
respondent,
the petitioner has not yet been released.
petitioner has been released from the concerned school, but not released by the deputy director
Then
of
where the petitioner is now then?
deputy director of this school education, SEPA, madam. Because this is inter-district transfer. We have to go from other district to other. For that, we are
No,
required.
that is why if you have been released, why don't you join the new place of posting?
My lord, with that posting, my lord, we require the final recommendation from the deputy director of school education of that concerned district.
But then deputy.
And for that, we have been hankering after him, my lord. So, having no option, my lord,
After release from the school, you will also require a release order from the deputy director also.
my lord, that deputy director is the final authority to my lord.
After release, you left the school already.
My lord.
Is it?
But yes, thereafter, in order to join to the new posting place, since this is
Now you see,
inter-district
now
transfer,
there is a transfer order issued by deputy director only. Whom, by whom?
transfer by
Issued
the transfer was made by the director, deputy, director of school education.
Whether the,
And my lord,
where it says that the DDSC required to issue.
my lord,
Where do
kindly,
we find that rule? That DDSC after release from the school, DDSC also required to.
my lord, this is the procedure maintained in the my lord education, not only
it?
education, my lord, this the deputy respondent number 3, deputy director is the my lord final authority of the district who need to give the final recommendation along with the my lord service book. And that has been denied, my lord. For that, we are not in position to join to their
No, they said, it said
respective
that,
class.
kindly terms and conditions, seek terms and condition. Okay. DDSC is directed to release all those transfer teachers.
Therefore, we need to transfer along with the service book, man. From the first day of join posting in the newly posted place, man, this service book is required. But this
No, that
service
is why I'm
has to
asking.
follow.
Service book will follow subsequently.
My lord.
Once you join there, service book automatically will come.
That
You
can
want to
be-
carry the service
My-
book along with you. How it can be
My lord.
possible?
not that I should carry it by myself, but along with the service book, along with.
You
two-
want that the service book should go first
Hello.
and then thereafter you,
No, my lord.
service book would
What,
create the
my
ground
lord?
for you
No, my-
to join there. No.
What,
Service book will automatically follow.
Definitely, my lord. But for that, in order to effect that inter-district, my lord, inter-district transfer, being the head of the.
Director has transferred.
The
On the
director
basis
has
of the transfer issued by the
And
director.
the director also already informed, recommended that they should be released. Now the final release is required from the DDSC.
Yes.
Concerned district.
Okay. He's not there.
It's not there.
Let him
However-
clarify. Let him clarify on Monday again. You're praying for Monday.
Yes. However, I have. been
Education
ins-
Department.
Education department.
Let him clarify
My lord.
on Monday. Because according to, normally, once the director issued transfer order, and once you are released, it is duty on your part to carrying with that release order, you can join in the
Lordship,
new posting place.
The instruction that I have received is,
Okay.
actually, director, he transferred, and DDC is the controlling officer of.
He
the-
need to release.
He has to release. Actually, principal or headmaster,
Hmm.
it is just a formality after release by the DDC.
Okay, it has to be
DDC
released by
has
the
to release
DDC
first, then he goes to school and he has to.
Okay, here the headmaster first
And-
release.
This is specifically mentioned in the terms and condition.
Hmm.
And in terms and condition 1, 2, the DDC principal are directed to release all those transferred teachers from the school as and when guest faculty of the same subject to join the institution, or else action will be initiated as per CCS. So this is instruction I
Okay.
have just.
So in the present case, the principal or the headmaster of the school has released before DDSC.
Because some are.
Now, is it the case? What he is submitting is that they should be released along with the service book.
Service book, because since the principal or DDC, because some are under the principal, the controlling officer of PGT, postgraduate teachers are under principal, and TGT, trained graduate teachers are under DDC.
Okay.
There are two sets
No,
of.
at the time of transfer, whether they need to carry the service
This
book
will
or-
automatically follow
it
because.
automatically follow
Yes.
only.
But for that, DDC or the controlling officer has to release, not the headmaster.
Exactly.
Because headmaster is not the controlling officer. He
But
is
then-
just the
But then even
supervisory.
if the school has, a school after release by the school headmaster or principal, have you left the school?
My lord. Because
You have left the school.
on the basis of release, my lord, we left. But
Have you informed the DDSC
My
that
lord.
you have left the school?
my lord, we have informed, since DDSC is not responding, my lord, we approached before the deputy director also. And
Oh,
even we appear before the president.
Where you say
of
that you have been
Dhaka.
released and then issue release order to the DDSC?
Page 28, my lord.
Okay.
Joint representation regarding the non-release of the transparent teacher from the DDSC office is coming, ma'am.
Or can we direct the DDSC to dispose of the representation?
My lord, let the notice be issued upon the, my lord, respondent number 3 as to.
Okay.
Otherwise, my lord,
So,
since
if
some
not
other
that-
matter is fixed on 4th, the standing council would be on.
My lord,
Same matter,
Not same matter, however.
no,
earlier
similar matter.
Not exactly similar matter. The item number 5 has also been listed on 4th. Therefore,
Okay,
matter may also be because he will clarify.
standing council will come.
Yeah, standing.
Let him clarify then on Monday.
my lord. no,
Okay. List is matter on Monday again. No?
My lord, along with this
And item
same
28 also, huh?
item 29, ma'am.
Sorry, 29. This is
Yes.
29. Okay. This is matter on Monday. Okay. I think. 13. It's 1. Should we continue or at 2? Huh?
My lord,
Is there any other?
Against other sides,
Take time, my lord.
My lord,
What is this matter about?
Transfer, my lord.
Transfer.
Transfer and posting.
my lord, can it be taken on Monday, my lord?
Why?
My lord, the leading counsel for the respondent is left the court premises.
Okay, what is the stage? Otherwise, the respondent appeared, file affidavit, etc.
Affidavit has been
Affidavit,
already
reply
filed.
not yet filed. You were to file reply or what?
I filed, already filed.
Already filed.
In respect of item number 14,
Okay, item
14, 13 and 14,
Analogous matter.
is
analogous. It is
Analogous.
attended by the
as prayed for by the learned counsel appearing on behalf of the state respondent.
No, my lord.
bank.
Hmm?
Bank.
Bank.
Yes. APRB. my lord.
Okay, for the respondent, list this matter again on Monday.
Yes.
My lord, interim order may be continued.
Staff, in the interim order shall continue till then. Okay,
Public.
Obliged.
15 also. 14,
13
sorry,
and
13, 14, okay.
But
Okay. Yes,
Your Lordship, the conducting council is out of station today, but I would like to make a request, Your Lordship.
appeal. When do you want?
Next week, Your Lordship, but I'd like to make a request, Your Lordship. Criminal appeal number 22 of 2024 may be tagged together, Your Lordship, along with this item number. Arising from the same FIR, Your Lordship.
When do you want that?
Next week, Your Lordship. Can you-
Next week?
Yes.
Your Lordship, I received paper book,
Paper book is prepared.
but it is incomplete.
Hmm?
The paper book is incomplete.
Incomplete.
Yes, index, this is written up to page 179, but it's only content up to page 90.
Okay. Mr.
Pironia.
Learned counsel for the
So
Applicant.
press copy of.
appearing on behalf of the learned counsel for the appeal. Staff. Mr. T. Tado. G. Tado. Learned additional ADPP submits that the paperwork is incomplete.
Incomplete, yes. Only contains 90, up to 90
Okay.
page. But
The
index.
the
is
index,
written
the index
179.
shows up to page
90,
90.
yes.
However, however,
As
how
per
much it
index,
is?
it
Index shows up to 90.
it has to be 179.
Oh, 179
Yes,
shows up to 179. However, the paperwork prepared by the registry contain only up to 90, page 90 stuff. In view of the above, the registry shall verify and correct the
Yes.
same accordingly.
press copy,
Correct, and prepare a fresh copy
yes,
after correction.
yes.
Okay, prepare a fresh copy, Staff, list this matter.
You-
After
Your-
the
If
paperwork
I
is
may, Your
prepared.
Lordship, criminal appeal number 22 of 2024
Staff,
may be tagged together.
In the criminal appeal number 22 also paperwork is ready. That we do not know,
No, Your Lordship.
because this is coming with the paperwork. We do not know about the criminal appeal number 22. If it is not ready, it will not come along with this.
Okay, sir.
Okay. List this matter after the complete paperwork is prepared. Okay.
Yes.
Okay.
Obliged. Obliged.
Your Lordship, I'm appearing on behalf of respondent number 2, private party that is. I was to file my counter affidavit, but I'm not ready with it. I would like to pray for some more time.
Okay.
And in regards to respondent number 1,
You are for respondent number 2.
I'm for respondent number 2.
You are for
2 and I'm for 1.
1.
You
No
will
one
be-
for the petitioner. No one
None for
appears.
the petition.
No one appears on behalf of the petitioner on call. Staff. Miss Vidara. Sorry. Miss. One more
For respondent number
for
1.
respondent number 1 and Miss S. Vidara, learning counsel for the respondent
LAC.
2. To legal aid counsel. S. Vidara, legal aid counsel are present. Staff. In absence of the learned counsel for the petition and the matter stand adjourned. Oh, sorry, you said that you require some time.
Yes, for
Okay,
counter.
SB Darang Learned Counsel, Learned Legal Aid Counsel appearing on behalf of respondent number 2, prays for some time to go through the petition.
Huh?
You
For
are,
counter affidavit,
okay. Prays for some more time to file counter affidavit.
Yes.
Or prayer allowed, list this matter after 3 weeks.
3
Okay.
weeks. Most obliged.
We'll finish it. Okay. Only two. Okay, yes.
Your Lordship, the respondents are yet to file the affidavit. Your Lordship.
You are for petitioner.
Yes. Okay.
Okay. You are Mr.
P. Ronia,
Land
appearing on
counsel for the
behalf
petitioner is present. The
of Tirita.
respond, what is your submission? What did you say?
I think the respondents are yet to file affidavit.
Not yet file affidavit?
No, I guess.
Additional, okay, you have filed additional affidavit.
Yes, Your Lordship.
No one appears on behalf of the respondent. Who is for the respondent earlier appeared?
No idea, Your Lordship.
There is no office note also. Additional affidavit filed only. In view of the above, the case stand adjourned. List this matter after 2 weeks. Okay.
Obliged.
Yes.
Lordship, here in this case, service report in respect of respondent number 2 is still awaited.
Mr. Kamo, Land counsel for the petition staff. The service upon the respondent number 2 is just a minute. Okay, 2 is still awaited. In view of the above, list this matter. after
Lordship,
2 weeks.
here interim order is there. Kindly, it may be continued.
In view of the above, list this matter after 2 weeks. Stop. The interim order passed earlier shall continue till the next date. Okay.
Obliged.
Yes.
Your Lordship, there's an interim order, item number 22. I forgot to mention.
23.
22, Your Lordship, the previous item.
22?
Yes, sir. There's an
22.
interim order.
The interim order passed earlier shall continue till the next date, huh? Okay.
Thank
This
you.
is 25. Yes. Last, okay, yes,
Here, my lord, we need some more time, my lord, to file affidavit, my lord.
okay. You are Mr.
Idagwami.
Land counsel for the petitioner is present. Stop. Miss Wang, you are Miss
T Wang Mu, my lord,
Yeah,
for,
Wang Mo.
for 1 to 4, my lord.
The other one is also Wang Mo.
She's
Okay.
K Wang Mu, my lord. I'm T Wang Mu.
Okay, that is right, okay. Land counsel appearing on behalf of the state respondent prays for some more time to file affidavit. The prayer is allowed. List this matter after 3 weeks.
3 weeks.
Okay. The interim prayer may be continued. Stop. Para. The interim order passed earlier shall continue till the next date. Okay. Done. Okay.